Morning, everyone. Welcome to our webinar on harnessing intellectual property. This is part of a series of ongoing training webinars for startups and entrepreneurs. This is one of various webinars we'll be doing over the next few months. And today we are going to be talking about intellectual property in very broad terms. I think the appointment is for 45 minutes or an hour, but I don't expect this talk to last more than 30 minutes. And it's probably 20 to 25 minutes of us talking and then a few minutes of Q&A at the end. So we're hoping to release a bit of time back to you. So let's get the slideshow started. And the thing with intellectual property is we hear a lot of clients talking to us about their intellectual property, and they tend to express it in fairly general terms, talking, in general about how do we protect our intellectual property or our IP, or I'm worried that someone's using my IP. And while intellectual property is a good kind of catch-all term for the kinds of things we're going to be talking about, lawyers tend to think of intellectual property in a different way. And I would encourage everyone to think about intellectual property in this way. And that is not as one thing, but as a series of different rights. And each of those different rights has different requirements, rules, benefits. And so, it's always helpful to think of your intellectual property in the categories in which they actually exist. And those categories are on the screen there. So part of what we hope to do after this talk is to allow you to identify within your own business what the actual intellectual property rights are that you have or might want to have, and how they're protected. And those rights are trademarks, copyrights, design rights, patents, passing off rights, and then trade secrets and confidential information, which is kind of all one category of confidential stuff. My colleague Satinder is joining me on the webinar, and she's going to talk about the rights, restrictions, and rules relating to trademarks, copyrights, and design rights.
Hello, everybody. Welcome to the webinar today. Thank you for the introduction, Guy. So yes, I'll be starting off with trademarks. So trademarks, badge of origins of goods and services. In other words, traders use these to differentiate their goods from those of other traders. A trademark gives the holder a statutory right to the exclusive use of the mark, such as the name or logo in connection with the goods and services. If the trademark is registered, then it can last in perpetuity, provided the registration is used in trade and renewed every 10 years from the date of the initial filing. Failing to renew will mean that a new application to register the trademark will need to be made, but this could potentially cause issues as there may be earlier identical or similar marks on the register. A trademark must be sufficiently distinctive in character, must not be purely descriptive in respect of the goods and services. For example, we could not register a trademark for solicitors in London because that would be both descriptive, it describes what we do, and not distinctive. The words cannot distinguish one firm of solicitors from another. And there must be no similar or identical mark for similar or identical goods in existence. Trademarks are only protected in territories it is protected in. For instance, if a trader applies for registration in the UK, then the protection is only afforded in the UK. There'll be no protection in the EU or USA or any other part of the world. An application must be made there for registration to gain protection. You can make an EU-wide trademark application, but most countries require separate registrations. As you'll see on the slide, the sign circle with an R, and you can see this on certain goods and services. This means the trademark is registered. use of this sign for an unregistered mark is a criminal offence. You can also see the sign TM, which is usually used in connection with an unregistered trademark, and there are no rules around the use of TM. My next topic is copyright. Copyright protects the expression of an idea, not the idea itself. It protects things like original literary, musical and artistic work, sound recordings, films and broadcasts, and typographical arrangements, databases, software, website layouts, etc. Copyright does not apply to titles or single words. Copyright is often thought of in artistic terms, but in a business context, copyright is very useful as it protects marketing material, websites, software codes, images, logos, etc. Copyright is not capable of being registered in the UK. Copyright protection is available automatically for all works recorded in any form, provided that the copyright requirements are met, which are that the works must be original and include efforts to make the work original. The duration of the copyright protection varies depending on what is being protected. Usually, copyright protection is for the author's life plus 70 years. However, for broadcasts, sound recordings, or computer-generated literary, dramatic, musical, or artistic work, the copyright protection is a period of 50 years from the end of the calendar year in which the work was made. Also, for typographical arrangements, the copyright protection period is 25 years from the end of the calendar year in which the edition was first published. UK copyright works are protected overseas by the virtue of the UK being a signatory to various conventions, the most important being the Berne Convention. This is very useful because it means that copyrights are protected internationally without incurring any costs. There are no further formal steps that need to be completed in order to obtain protection in the convention countries. My third topic is design rights. Design rights provides protection for the appearance of the product or part of a product. There are both registered and unregistered design rights. In order to qualify as a design right, the product must satisfy the following characteristics. A design to qualify must be new and original. A design must be individual in character. This means it must give a different overall impression from earlier designs to the informed user. A design right prevents third parties from being able to produce, sell, export, or import products in which the design is incorporated. However, unregistered design right does not include protection for service, decoration, and generally only covers the 3D shape of the design. The duration of the protection is unregistered design 3 years from the point that the design is first disclosed or made available to the public, and registered design can last for 25 years, provided that every 5 years the renewal fee is paid. Design rights are a means for protecting contours, colors, shapes, textures, and materials of a product or part of a product. Protection for registered design right is afforded in the given territory only, i.e., you only get protection in the territories you apply for the design right registration. The right to register is lost 1 year after disclosure of the products in the UK, but this may vary for other countries. I'm now going to pass on to Guy, who will talk about patents next.
Thank you, Satinder. So as Satinder was saying, the design right is there to protect the appearance of a product, kind of what a product looks like, both in terms of 3D shape and also, well, registered designs at least, even patterns, surface decoration, that kind of thing. A patent or a patent is a form of right, one of the oldest forms of intellectual property right, and it's there to cover inventions. And the intention behind a patent is it's there to cover an invention that has a practical application. And the key thing to understand about a patent is it protects, how something is done, not what is being done. So it's there to protect the underlying technology. And a patent, if granted, so for instance, in the UK, would provide a monopoly right for 20 years. You have the exclusive right to use that invention. However, there is a quid pro quo with the patent, which is that if you want to get patent protection for an invention, you have to disclose what it is and exactly how it works. And that disclosure requirement often, puts some people off an application for a patent. In order to get your patent, it has to be novel, i.e., new, and non-obvious. So if you can work out, if someone reasonably skilled in that field could come up with this fairly easily, then it may be treated as obvious and not patentable. One key thing to remember about the invention needing to be new is it's the invention itself that has to be new, the how and not the where. So if you are taking an existing piece of technology and you are deploying it in a new field or a new sector, then that is not going to be capable of patent protection, because the how, the technology that you're actually using, is already in use somewhere else. So, an application of an existing technology in a new area is not capable of patent protection. Now, in the UK and in Europe, software and process patents are notoriously difficult to obtain. It is easier in the United States, so notoriously, Amazon managed to get a patent for its one-click ordering process. That's the kind of thing which can fly in the US, although even there they are seeking to limit and cut back on the number of process and software patents that are granted. It is possible to get them, but it is difficult. Patents are also specific to given territories, just like registered design rights and trademarks. There is a European patent application, but other than that, you're going to have to apply in each territory separately. So, for all of those reasons, many businesses decide not to pursue patent protection. Now, certain sectors, in certain sectors, patent protection is absolutely vital. Pharmaceuticals, mechanical engineering, other areas where there are, clearly patentable inventions that need to be protected. Now, in the field of software, for instance, and related technologies, patents are quite rare, not just because they can be difficult to get, but also because of this disclosure requirement. So, for instance, Google has never tried to obtain a patent for its search algorithm because it prefers to, put it in a black box and keep it confidential indefinitely. And, you know, for that reason, many businesses choose not to pursue patent applications, but it may be valuable. I'm now talking about passing off. So passing off is not really an intellectual property right. It is a cause of action. It's a right to stop someone from doing something. So it's effectively it's a right to sue someone in certain cases and be awarded damages or an injunction. And what the passing off right gives you is the right to stop someone from representing that their goods or services are yours. So they are, copying or using some very similar branding, designs, marks, words, logos, which cause confusion in the marketplace. Now, to bring a claim for passing off, you have to show that you have reputation or goodwill in your original branding. You have to show misrepresentation, which does not mean deliberate, fraudulent, trying to poach your customers by using similar branding. What that really means is that there is some actual confusion out there between, your goods and services and the goods and services of the person who is passing themselves off as you. And then finally, you have to show that you've suffered damage, actual loss. And because you have to show all of these things, it is a notoriously difficult and expensive claim. And we would always recommend to our clients that they pursue a registered trademark if they can, so they're not relying on what are sometimes called unregistered trademarks, which really means a passing off right. So if you can, do try and get a registered trademark. It is much more valuable than a passing off right. However, a passing off right may be um, all that is available if people are copying aspects of your branding which are not protected, or if you have some aspects of your branding which you cannot protect with a trademark, which may be entirely possible. I'm now going to talk about our final category of intellectual property right. And this is, one of the most important, especially for, startups and growing businesses. And that's the general area of confidential information, NDAs, those kinds of things. So starting with trade secrets, which are a specific type of confidential information, particularly valuable, particularly important. And, trade secrets usually refers to, a piece of information which is critical to a business and provides it with a competitive edge. The classic examples are recipes. So recipes cannot be protected by any of the intellectual property rights that we've just been through. Copyright will only protect for a recipe the specific way that it's described, the words that are used to describe the recipe. Copyright does not protect the underlying information in that recipe. And the same goes for, formulas, manufacturing processes, business methods, customer methods, and forms of data like customer lists, and some aspects of software as well. Software code is protected by copyright, but other aspects of how software may works, aspects of its architecture, perhaps, um, data that software has recourse to or access to. Some of those things may not be protected by another right, and so you're relying on it being a trade secret and keeping it confidential. So having said that, trade secrets are essentially just a form of confidential information. How is confidential information protected? Well, as I just said earlier, it's not technically an intellectual property right. It is more of a cause of action, like passing off. It's a right to stop someone from doing something or claim damages if they've done it. In order to protect information as confidential information, it's necessary for the information to have the, quote, necessary quality of confidence. That is a typically unhelpful, description of a judge as to what confidential information is. There was a bit more helpful guidance given, which is that the information has to have limited public availability. Now, what that means is that it's not just in general information in the public domain. If information is out there, it's accessible and available to everyone, then it's not going to be protectable as confidential information. Doesn't mean that it has to be completely secret and nobody has access to it anywhere. It just means that it has to have some restrictions on its accessibility. The information also needs to be capable of clear definition. So you need to be able to point at a body of information and say that is what is protected. If it's too vague, then again, it may not be protected. And the final test is there has to be an obligation of confidentiality in relation to that information. Now, that can be an express statement that this information is confidential. In many cases, the obligation of confidentiality can be implied by the circumstances. If it is clearly a very secret recipe for something very valuable, then it may be that an obligation of confidentiality can be assumed. Before I talk about NDAs, which will be the sort of the final thing I go into, I do want to talk about business ideas and concepts, because particularly for startups, there is a lot of confusion around business concepts and ideas. And to put it bluntly, in general, a business concept or a business idea simply is not protectable by any form of intellectual property right. So a description of what a business does is not, a general sector market, even if it's perceived as being unique or something that no one else has done before, that is not protectable. And a copycat can come along and, copy what you've done and copy your business concept. As long as they're not using your trademark or anything similar, they're not using any of your copyright materials, they're not using any patented inventions if you have any. You simply cannot stop someone from saying, oh, that's a clever idea what they've done. I'm going to do it in a different way under new branding and so on. Now, there may be a stage in which a business concept is protectable, and that is before the business launches. If the business is not yet launched, so it's not in the public domain, then you may be able to, through an NDA or other form of confidentiality agreement, prevent what you're planning to do from being leaked. But those cases are rare. So the final thing I'm going to talk about is NDAs. Are they necessary? Are they worth the paper they're printed on? A lot of people have a lot of views on them. And I suppose my view on NDAs is they are certainly useful because they help to meet those tests referred to on the slide. They help to demonstrate that there is some information that is capable of definition because you've defined it in the NDA. And they also state that there is an obligation of confidentiality in relation to that information. Having said that, an NDA cannot protect information which is not by its nature confidential. So if information is in the public domain, an NDA will not help you. And in many cases, an NDA may not be necessary because it's so obvious that there is an obligation of confidentiality in relation to the information that actually, you are protected even without an NDA. Having said that, they are certainly, useful things to have, and they don't really do any harm. But if someone is refusing to sign an NDA, you may need to weigh up whether actually it's still important that I give this pitch or provide this information. I think it's obvious that this information is confidential. I'll put a big sign on the bottom saying this is confidential. And even if they have, on principle, refused to sign an NDA, they may still be subject to obligations of confidentiality for that information. Simply saying that I'm not signing an NDA does not mean I'm off the hook from any confidentiality obligations whatsoever. So that's the end of a sort of brief canter through the intellectual property rights. Now, just to kind of summarize in 30 seconds what they are again. So we've got trademarks, which are registered, relatively low cost. They do need to be protected internationally in different territories, but are very useful for SMEs and startups. Copyright is incredibly useful because it's free and it's international from day one, although it only really covers, text, images, designs, software code, crucially, and some aspects of databases and data. Passing off, which is a bit tricky, design rights, which are very useful for specific sectors, clothing, homewares, that kind of thing, and patents, which again, if you're in a sort of high tech sector, may be useful, and confidential information, which applies to every business in one form or another, and again, is generally fairly low cost to protect. So with now that we've finished the sort of main part of our talk, I wondered if there are any questions. Please do put questions into the the Q&A box if you do have any, and I'll just give that a couple of seconds. We do have a question about how to manage an international rollout of a business. I mean, this is something which comes up a lot. So clearly, when a business starts to trade, it's usually starting off very much based in its home territory. Let's assume the UK for now. And the way technology has developed, it's very easy to expand internationally. And there can often be a thought, well, it's going to cost a fortune to protect, say, a trademark in every potential territory where someone might download our app or access our website. I mean, in those circumstances, what we would generally recommend is, protect your core markets. And then as you gain traction in specific areas, in specific territories, then, look to protect in those territories. But it's generally not worth the investment to go out and seek protection globally from day one. It's just simply too expensive. I've got a question about AI and generating a logo, which is a very good one. So is there anything we should consider when using AI to generate a logo? Well, I suppose the first thing you've got to consider is the terms and conditions of the AI platform. So, I think most AI platforms do say that they claim no ownership of the IP in the outputs. Now, the AI platform claiming no ownership in the outputs is not quite the same as saying you own the IP in the outputs, because they're a bit nervous about saying that you own the IP in the outputs because they're not 100% sure. I mean, generally, I would, well, be cautious with using any AI outputs in this way. So one option would be to use an AI to, if you like, workshop your logo and then get the final version prepared by a designer. That will give you some cover. I mean, there are other more practical things you can do. Put the logo into a reverse image search on Google to make sure that it hasn't simply copied another design. The problem is that if someone pops up and says, you've copied my design, you will not have, proving that you didn't will be very difficult if you've used AI to create that logo. Whereas if you've used a designer, it's quite straightforward. The designer says, no, I confirm I didn't. Here's some evidence and some records. Having said that, it's not necessarily, going to be an infringement. It may be that the logo is sufficiently unique, different. You've done enough searches that you're comfortable using it. Anyway, that's a very good question, Martin, and that does come up a lot. And then I've got a question about IP and employment. And sorry, yes, that's something that we didn't cover in our talk, but is quite important. So we often get asked by people who are working for one business, thinking of setting up another, and they're working on some materials, and the question is, does my employer own what I'm working on? Well, the general rule is that if you're creating copyright materials, and there's usually we're talking about copyright here. If you're creating copyright materials in the course of your employment and you are an employee, that the rights will be owned by the employer. If you are self-employed, if you're a contractor or consultant, if there isn't a contract which says otherwise, then the rights will be owned by the contractor, even if the employer, the client, is paying for the work. The contractor still owns the intellectual property rights, and there's a license for the client to use the work in those circumstances. So if you own works that you create in the course of employment, what does the course of employment mean? Well, sometimes it's defined in an employment contract, or people try and define it. But generally, it means if it's part of your work and the type of task that you could be asked to do as an employee, then it will be owned by your employer. Clearly, if you are, employed as an accountant and you write a novel, your employer is not going to own any rights to the novel. But if you're employed as an accountant and you develop some, new methodology spreadsheet for doing a cash flow analysis, then there may be more of an argument there. So there's sometimes a bit of a grey area. Usually, it's fairly clear, and I think that is all the questions we have. Thank you, everyone, for joining. Please look out for future webinars on other topics, which will include data protection and GDPR. Thank you.